You know, the biggest problem with the difference between constitutional history and constitutional law, I think, having taught both and having been involved in debates in both, is constitutional law really, the first line of any effective piece of writing is, may it please the court. And it's really about persuading judges, usually on some kind of appellate level. And the first line of any history is almost always something on the order of, things were really much more complicated than we thought. Although, obviously, we sometimes vary that to make it more interesting in terms of style. But the upshot is, historians always start with this idea that the past is much more complicated, much more ironic, there are more twists and turns, and it doesn't fit neat categories that fit our lives because they had different issues. The law, by definition, starts with our issues today. That's why something has gone to court, not because we're trying to sort out what the Second Amendment meant during Reconstruction. We want to know what it means today. So there's a fundamental tension between the way lawyers use history and the way historians write history. Now, some people would say there's no way to reconcile the two. I myself think that it is possible to do history well, stop, take a breath, and then say, what, if anything, is useful from this for the law? I think the big problem is people just say, I'm just going to go look for the history and find stuff that's useful without stopping to get the history right, pausing to say, maybe there's nothing here for me. It's really interesting, it's really important, but it just can't be made to fit into the little square pegs that we've created in our modern legal system.
So was that case the Cruikshank that you mentioned?
The case that I mentioned was actually United States versus Mitchell. Or, sorry, scratching my nose. The case that I mentioned was actually United States versus Mitchell. Cruikshank is the next big case that involves the Second Amendment. That one is much better known. Cruikshank results in a Supreme Court opinion. Mitchell is a little more complicated. Mitchell goes up to the federal court on a kind of complicated procedural issue, and we don't get a Second Amendment ruling. We get, I'd have to check, I'd have to actually reread the section of my book because it's not a case I teach or use very often. But Mitchell gets resolved in a way that doesn't give us a clear statement. In fact, the problem in the South Carolina KKK trial is the federal attorney is waiting for the result of this Mitchell case to know whether or not he can make a certain line of argument. And the court sort of disposes of the case on a more technical kind of grounds, and therefore he's left high and dry when he would have really liked to have had a good precedent to work with.